I'm not ready to go yet, okay? I'm not ready. You gotta wait. I got shit to do. I'm in the middle of something, all right? Just hold on.
Watch your mouth or don't come in here.
Uh-oh.
Oh, yeah, people, come on, we're adults here. You know what? What is the point?
Yeah, we're adults here. I got a fucking Burger King fucking thing on my head. We're all fucking adults here, guys. People in my chat, 2 words. What are they? 2 words. Let me see the chat flood. Let me see the chat flood. 2 words. Okay, next caller. Please. Let's get into the meat and potatoes, which translate in American to dick and balls.
I got flip-flops. These are my flip-flops. Yeah, I really like my flip-flops because I can put them on. Because look, watch me put them on. I can put them on all by myself. Watch me put them on. Look, are you watching? Look, these are my flip-flops.
Thanksgiving Day. I remember it clearly. It was Thanksgiving Day. I was inserting myself in somebody else's fucking business as a cash grab, and you know. This channel is harsh reality.
Karen jak se jodió la sucia vida. Amen.
This is Jonathan Lee Riches. I have cheeseburgers. I'm gonna put cheese on them. I'm gonna make sure that I have my hamburgers because I'm a big boy now and I can make the hamburgers. My mom lets me use the stove now.
And I'm just like, wow, I like receipts, and they brought receipts. Like they had evidence to back up everything they said. And I'm like, okay, well, there's got to be another side to this, right? Like, this can't. No, this is too fantastic.
Yeah, because you're not going to just jump to the conclusion that there's a conspiracy amongst cops to cover up a murder. You know what I mean?
Yeah, I mean, cops and just like soccer moms and shit. Like, that's what made it even crazier. Like,
yeah, get it, Betty. Yeah,
did you have a close relationship with your mom?
Get it, Betty.
Oh, of course, I still do.
Yeah.
My older sister was kind of sad. She was more of the prissy girl that likes going.
That is the best shit fucking
shopping
ever.
for the dresses with mommy. I was the tomboy that liked playing with the feet.
Shout out to Cherry for just being easily the most faithful and loyal supporter that I've ever had, man. That someone could have that tenacity with loyalty. And I'm really blessed to have someone like Cherry be part of this channel and in my life. So it means a lot. And yes, I named him after Mr. T and Rocky. Say, woman. Say, woman. Say, woman. Since your old man ain't got no heart, why don't you come down to my apartment tonight and I'll show you a real man. Oh my God, I'm so in love with this little dude. Yeah, I'm going to go ahead and wrap this one up. I love you guys very, 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 very much. And we will do this again very soon, my friends. Oh, say bye. Say bye. Oh, I love you too. Give me a kiss. Oh, I love you. Bye, guys. Welcome, everybody. Oh, my goodness. People, first of all, I want to apologize for the late start and the technical difficulties. I just got a lot going on right now, and I was trying to juggle it all, and I failed. So, but here we are. I appreciate you guys joining me today and hanging out. Dude, so listen, big news today. Big news today. Let's check out some of this stuff real quick. Let's check out get an idea, a little summary right now of what's been going on. Give me 1 second here. Let me pull this up. My God, my computer is just going nuts today. All right.
We are following major breaking news right now in the Karen Read mistrial. Her defense team just moments ago filing a motion to dismiss 2 of the 3 counts against her, including the charge of second-degree murder and leaving the scene of a deadly crash. So her trial ended last Monday in a mistrial. We reported on it extensively, right? A jury could not reach a unanimous verdict on all 3 counts, but according to the court documents filed today, her lawyers now say they have since heard from 3 jurors that the jury did, in fact, have a unanimous decision to acquit her on those 2 counts. In the filing, they say a retrial on those counts would violate double jeopardy protections. Again, Karen Read's lawyers just moments ago filing a motion to dismiss 2 of the 3 counts against her, including that most serious count of second-degree murder. We're going to bring you any updates as they come in, but certainly this is massive news happening today in the Karen Read trial. Now, all of this news is coming down on the same day that the lead investigator in that case could learn his fate. Thanks for being with us, everyone. I'm Melody Mendez. So let's talk about Trooper Michael Proctor for a moment. He was relieved of his duty. He is now the subject of an internal investigation by Mass State Police. In fact, that investigation began before the trial even started. But now there's a hearing getting underway any minute now about what happens next. So NBC 10's Manoj Kungwari live in Framingham. Manoj, what can we expect from this hearing today?
Well, we know that it means that Trooper Michael Proctor will have one more time to defend his actions before his superiors here at the department ultimately determine his future. Now, this whole thing is really centered on inappropriate texts he sent while he was serving as lead investigator on that murder case. Those texts came to light during the Karen Read murder trial. And in fact, in some of those texts, we saw that he was talking to family, friends, and colleagues, referring to Karen Read as a, quote, whack job. And one text to his sister, Proctor said, quote, hopefully she, meaning Karen Read, kills herself.
I think I've been very clear, and I want to remain very clear. Misconduct in any way, shape, or form of the Massachusetts State Police will not be tolerated. I think I've said that I condemn those comments in the strongest terms possible. They are not reflective of the Massachusetts
That guy looks
State
like such an
Police.
asshole.
Not what we want to be in as an organization.
Well, after being relieved of his duties last week, Proctor was transferred from the Norfolk County District Attorney's Office to Troop H at the Mass State Police Department. He is currently getting paid, but is not actively working. His car, gun, and gear have been taken away, which is standard practice. After today, one of these 4 things on your screen could happen. He could either be retained on full duty, placed on restricted duty, suspended with pay, or suspended without pay. Now, I can tell you that the hearing is beginning right now. It should have started just a couple minutes ago. A spokesperson with the Mass State Police Department tells us we expect to learn exactly what happens in there this evening. Once we do, we'll update you. But for right now, we're live here in Framingham. Manoj Kungwari, NBC 10 Boston.
So very interesting stuff here, because in regards to Trooper Proctor, there is a standout right now. There is a protesting his mere employment with the Massachusetts State Police. And that is the usual folks who have been outside the courthouse, not only in Karen Reed's hearings, but also in the never mind. In the Karen Reed hearings, but also Turtle Boys hearings. They have been showing up to this courthouse prior to the trial even beginning. Now, we're going to get into all of these things. Let me real quick. Paul O'Keefe's crotch. Jesus. Thank you, Lizzie. Come get your boy. And Chloe Albert's revenge. Proctor's being adjudicated in Framingham. Wow. Talk about irony, right? Agreed. Right. Yeah. So big shout out to all those folks out there. Paul Cristoforo, Dana, Tracy, Scott McGinnis, Tom CPU, Rita Lombardi, all of those amazing people that have been supporting Karen Reed all this time, supporting Turtle Boy, are out there making their presence known and making their disapproval of the mere employment of Michael Proctor as a Massachusetts State Police officer, making their grievance with that very, very public and very now respectfully, but very public. Christy says, exact reason the jury should have been polled. Look up Jessica Chambers, the teen here in Mississippi that was burned alive. 2 jurors said they voted guilty instead of not guilty, and he walked. Yeah, I mean, that's Mississippi, though. I don't think that there's jury polling in Massachusetts. I don't think that's a thing. So, unfortunately, it's just one of those things that we're just going to have to eat. Now, we are going to go over these filings. We are going to go over these filings. Now, mind you, I'm not a lawyer, and I haven't done anything in regards to this news except I read a TMZ article, and I got or rather, I had Cherry get the court filings, the filings from Karen Reed's defense, so that I could read them, because you guys know that I like to do reactions to these things live. Now, because I'm not a lawyer, I'm not going to probably fully understand them. So just a disclaimer there, but I'm going to do the best I can because I'm absolutely interested in this. And it sounds like this is really good news. So let me just go ahead and pull up the okay. I think I just got 2 of the same thing here. Hold on. Okay. All right. So, Karen Reed's defense have filed a motion to dismiss at least 2 of the charges. So we're going to go over this right now. And it says here, defendant Karen Reed's motion to dismiss. Now comes the defendant Karen Reed by and through undersigned counsel and hereby moves this honorable court pursuant to the 5th, 6th, and 14th Amendments to the United States Constitution and Article 12 of the Massachusetts Declaration of Rights to dismiss counts 1 and 3 currently pending against her on the grounds that the jury reached a unanimous decision to acquit her on those charges, and alternatively, because there was no manifest necessity supporting the declaration of a mistrial with respect to the charges on which the jury had agreed that Miss Reed was not guilty, and that therefore a retrial on such counts would violate the double jeopardy protections of both federal and state constitutions. Wow. God, this is going to be fascinating because, I mean, what's Bev going to do? What is Bev going to do? That's the big question here. So let me continue reading here. The ancient right to a jury trial is no mere procedural formality. Here's where we're going to get into some poetry, folks. This is what I love about Karen's defense team. But rather a fundamental reservation of power to the American people. Erlinger versus the United States. By requiring the executive branch to prove its charges to a unanimous jury beyond a reasonable doubt, the Fifth and Sixth Amendments seek to mitigate the risk of prosecutorial overreach and misconduct, including the pursuit of pretended offenses and arbitrary convictions. Wow. This is fucking great. Prominent among the reasons colonists cited in the Declaration of Independence for their break with Great Britain was the fact Parliament and the Crown had deprived them in many cases of the benefits of trial by jury. After securing their independence, the founding generation sought to ensure what happened before would not happen again. As John Adams put it, the founders saw representative government and trial by jury as the heart and lungs of liberty. It follows that a jury acquittal is entitled to the utmost respect in our criminal justice system. And I love how it's so interesting to hear Lally quote John Adams, and it infuriated everybody, including me. I was like, oh, shut up. I was like, dude, shut up. Like, it made me really mad. But when I hear Karen Reed's defense team quote John Adams, I am stoked. Like, I get so psyched about it. It's fascinating. It's amazing. So the double jeopardy clause provides that no person shall be subject for the same offense to be twice put in jeopardy of life or limb. Okay? The clause guarantees that the state shall not be permitted to make repeated attempts to convict the accused, thereby subjecting to embarrassment, expense, and ordeal, and compelling her to live in a continuing state of anxiety and insecurity, as well as enhancing the possibility that even though innocent, she may be found guilty. I'm going to read that one more time, okay? For those of you who don't know what the double jeopardy clause is, what double jeopardy is about, and why double jeopardy exists, why it's so important, folks. It's so important that the prosecution, like those of us who follow true crime cases, right? There's so many of us, and this includes this case too, okay? Let me just leave it that simple, okay? For those of us who are sitting here going, why is it taking the feds so long to throw down some indictments here? Why is it taking the feds so long to indict Michael Morrissey? Why is it taking the feds so long to indict anybody who they feel, if they've discovered what happened to John O'Keefe, who was responsible, why is it taking them so long to act on this and to start handing out indictments? This is why. This is exactly why. Okay? Because if you get it wrong, if you hand out these indictments and then you go to trial, right? You charge somebody and you go to trial, and that person is found not guilty, okay? Not guilty. But then solid evidence comes later. I'm talking damning evidence. I'm talking video footage and a smoking gun. Video footage of the smoking gun being fired, and then the smoking gun even being recovered. And that's all the proof. But you already put this person on trial. They've already had their right to due process. They've already been through due process. Double jeopardy is important to preserve the rights of anybody who is being indicted, who is being prosecuted. Okay? And for the reasons, it exists for those reasons. But there's two sides to that coin. And the other side of that coin is what I'm explaining right now. The one side, the reason why it exists is the side that is why it even exists, is the double jeopardy law, which Karen Reed's defense explains here. Now, the reason why it's taking the feds for so long, or I should say, I don't really know, but the reason why I'm patient, personally me, why I'm patient with the federal investigation and what they're doing, is because you have to get it right the first time, because anybody under any accusation has rights. They have civil rights. They have civil liberties, and you cannot violate them. And these are the things that I love about this country. But just like, you know, I like to be able to say whatever the fuck I want without being censored, without being stifled. As much as I love to say whatever the fuck I want, that also means that I'm going to have to hear things that I don't like. There's no escaping that. If I want that right to say whatever I want and tell people, hey, suck it up, don't listen to it if you don't like it, that means that the same goes for me. So there's always two sides to everything here. And so the reason why it's taking so long, or at least, again, I have to correct myself. The reason why I'm very patient with how long it's taking the federal government, the DOJ, the FBI, the Attorney General's office, or the U.S. Attorney's office, excuse me. The reason why that I am so patient is because I don't want them to use this. I want them to meticulously and carefully collect the evidence needed to ensure that those responsible for not only framing Karen Reed, but hopefully those responsible for John O'Keefe's death, those actually responsible, though they get prosecuted and there's no mistakes, that it ensures their prosecution. That is what I am so hopeful for, and this is why I'm very patient, is for this reason right here. Because I don't want them to use this. I want a thorough investigation done the very first time, and I think that that's exactly what they are doing. I believe that. I have to believe that this is exactly what the U.S. Attorney's Office is doing. These things take time. Building a case that cannot be refuted with any doubt by a jury of their peers, that takes time. To make sure that no defense attorney can go, yeah, but to anything. And that takes time. And this is exactly, ironically, what Lally and Michael Morrissey's office absolutely failed to do with Karen Reed. And I mean absolutely failed. And when I say absolutely, I mean it in the truest sense of the word. There's not one piece of solid evidence against Karen Reed. Joseph Sands, thank you so much. DNE has a new delivery guy, Lil Mikey P. Okay, cool. Thanks, Joseph Sands. I appreciate it. I hope he smells better than Jim Ferris. From what I understand, I've never smelled Jim Ferris before. Ugh. Knocking on wood. But from what I hear. So the wheels of justice are slow. Okay. Now, again, I'm going to just, after I explained what I just explained, I'm going to read this one more time so that we all have a better understanding. The double jeopardy clause provides that no person shall be subject for the same offense to be twice put in jeopardy of life or limb. The clause guarantees that the state shall not be permitted to make repeated attempts to convict the accused, thereby subjecting her, meaning Karen, to embarrassment, expense, but it's him or her, but they specified her in this, but this is the clause. Thereby subjecting her to embarrassment, expense, and ordeal, and compelling her to live in a continuing state of anxiety and insecurity, as well as enhancing the possibility that even though innocent, she may be found guilty. Perhaps the most fundamental rule in the history of double jeopardy, jurisprudence, has been that a verdict of acquittal could not be reviewed on error or otherwise without putting a defendant twice in jeopardy and thereby violating the Constitution. And they cite some other cases here. Here, the very day after a mistrial was declared, undersigned counsel began receiving unsolicited communications from 3 of the 12 deliberating jurors, indicating in no uncertain terms that the jury had a firm 12-0 agreement that Miss Reed was not guilty of 2 of the 3 charges against her, including the charge of murder in the 2nd degree. Given the certain importance that acquittals have held in our criminal justice system for hundreds of years, the defense respectfully submits that the jury's unanimous agreement precludes re-prosecution of Miss Reed on counts 1 and 3 and mandates dismissal of those charges. Alternatively, to the extent that the court believes further factual development is required, the defense respectfully requests that a post-verdict inquiry be held on the issue and that the court authorize defense counsel to seek additional proof from the jurors regarding their having unanimously acquitted the defendant of 2 of the 3 charges against her prior to indicating to the court that they could not reach a verdict on the 3rd charge alone. They had to, Now, I don't fully understand. I'm going to keep going here in a second here, folks, but I don't fully understand, folks, what Judge Bev thought she was doing. She had to have been aware of this. She had to have been aware of this. She had to have been, somebody in that jury had to have come to her the same way that they came to the defense and made her aware of this. And why didn't she do anything about it? Now, the defense could just be blowing smoke. This could just be yet another, just the defense doing what they're supposed to be doing. Any defense attorney could just be, listen, I'm not doing my job unless I'm filing motions. Throwing fucking shit at the wall to see if it sticks. I'm going to see if, maybe I could catch Bev in a good move and then, or she's a little overwhelmed with how her day's going and then just decides to sign off on the goddamn motion and grant it. Maybe. That's what they say sleazy defense attorneys do, right? The problem with this theory is that this is one case where the defense attorneys are, sorry, I'm getting distracted here. Something's wrong with my audio. All right, hold on a second. Okay, well, I can't really do anything about my audio right now. That was one of the problems that was happening earlier. So if you guys can hear me, I'm just going to have to settle for you guys being able to hear me. So, so my issue here is This is one of those rare occasions where the person sitting on trial is absolutely innocent in a very high profile case. And the fact is, the reason why it's so high profile is because of the lack of evidence against her. And yet they're moving forward and everybody's wondering why. Because the majority of people that have been following this case before it even started to trial believe that Karen Read was innocent, based on what the prosecution was trying to say was their case. But the prosecution didn't seem to have a case. And then the entire time, throughout the entire duration of the trial, we waited and waited and waited and waited for the prosecution to lay us out with some new evidence or some evidence that we haven't heard of. Right? But they never did. They never did. It never happened. The prosecution never presented any solid evidence against Karen Read. Now, how the jury ruled is how the jury ruled, right? There's nothing we can do about that. But it was interesting because something just didn't sit right. We're sitting there and we're fully aware of the fact that, you know, us laymen's are thinking to ourselves, if I'm on this jury and I understand the concept of reasonable doubt and I understand how that works, then why is this jury split? Because I can't think of one thing that the defense didn't present doubt on. I can't think of one piece of evidence that Lally had presented. I can't think of one thing that made me think, oh, well, that's pretty bad on Karen. Ooh. I can't think of one thing. It had never happened. And then there's the issue with the jury forms. I'm seeing people talk about that in the chat too. The issue with the jury forms, the defense, I don't know if one has anything to really do with the other. I'm not sure. But one thing that makes perfect sense is that the jury forms could have absolutely confused the jurors. And the defense was already having issue with it. And Beverly Cannoni fought Alan Jackson on this. And when it was pretty much established that this was confusing to the jury, this had to have been confusing to the jury. After Beverly Cannoni's answer was, well, this is how I've seen all these jury questions. This is how I've always seen these things written out. And then she goes, right, Mr. Yannetti? And, you know, Yannetti's like, actually, no, Your Honor. Which I thought was fucking hilarious. But it makes sense that this could have confused the jury. But I'm very, very, very interested. I'm very interested to find out what actually happened in that jury room during deliberations. Yeah, good point. I mean, she didn't take off her shoes, folks. That's lock. I mean, how she's not locked up right now just for that is beyond me. So here's the background to this here. It says here on June 9th, 2022, Miss Read was charged via 3 separate indictments with murder in violation of MGL Chapter 265, Count 1, vehicular manslaughter in violation of MGL, Whatever. Look, I'm just going to skip those because we're laymen here. Vehicular manslaughter and violation. Vehicular manslaughter and leaving the scene of personal injury or death in violation, blah, blah, blah. A jury trial began on April 16th, 2024. On June 25th, 2024, the jury began deliberations. Okay, so count one is vehicular manslaughter and leaving the scene of personal injury or death. And July 1st, 2024, when the jury presented a note to the court, all counsel were ordered to the courtroom. The note was not presented to counsel for review. Rather, the court indicated that the jury was at an impasse. Once the jury was seated, the court then read the jury note verbatim in open court and without providing any opportunity for defense counsel to be heard. The court declared a mistrial and excused the jury. In short, neither defense counsel nor the defendant consented to the mistrial. Wow. While the juror's note, as read by the Honorable Court, indicated the impasse was on charges, it did not say whether the charges were those within count two, the multiple ways to find guilt, or count two, or extended to other counts. The affidavits attached herein indicate the former, not the latter. Huh. Yeah, it was just on charges, right. And the court never ascertained from the jury whether its deadlock was in relation to one, two, or all of the charges in the indictments. Wow. Okay, right. Because that's the thing is I thought that was weird too. I thought that was kind of weird. I just didn't want to sound stupid saying something about it. I do that enough as it is. So I thought that was kind of weird because I feel like I may have said something about it, but I remember thinking about it. Where I know that other trials, they read off the counts and what they're guilty on. So isn't it fair to like question which counts? I'm pretty sure I said something about this the day of. I'm not 100% sure though, but I know I thought about it. Because I was like, that's kind of weird. Like, shouldn't we know specifically what charges they're at an impasse on? That kind of doesn't make sense. You know, like if certain charges bring certain if certain charges bring certain sentences with them, if they're found if they're convicted of them, then you know, doesn't it make sense to differentiate them, right? Which is why I assume they do that. Like whenever they read off, okay, we the jury find the defendant on count one not guilty, blah 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 blah. We the jury find the defendant on count two guilty, blah blah blah. This happens in every fucking trial. So why I thought they're just at an impasse? Like, is it all the charges? Wait, are there two Paulo Keeps crotches in my chat right now? Like having it out? Are you guys seriously are you seriously having a dick sizing contest right now in my chat? Incredible. Okay, great. Okay. Sorry, I like to mute when I drink my coffee. Okay. Whatever you say. The following day on July 2nd, 2024, Attorney Jackson was contacted by a juror in this matter who stated that he wished to inform Alan Jackson of the true results of the jury's deliberations. According to Juror A, the jury unanimously agreed that Karen Reed is not guilty of count one, second-degree murder. Juror A was emphatic that count 1 second-degree murder was off the table. Holy shit. Holy shit. This is just mind-blowing. It's just got me.
I think we got a super chat. Super chat. I think we got a super chat. Super chat. Super chat. Super chat. I think we got a super chat. I think we got a super chat.
Christy, thank you so much. At least one juror said they felt intimidated by the asshole sitting with John's family when they came in and he was in there. Okay, cool. Thank you. No spoilers. I'm just kidding, guys. It is a minimum $5 super chat charge for spoilers. Feel free. Otherwise, no spoilers. Thank you so much. Juror A was emphatic that count 1 second-degree murder was off the table and that all 12 of the jurors were in agreement that she was not guilty of such crime. The jury was unanimously agreed that Karen Reed is not guilty. Oh my gosh. All right, I'm going to skip the song because I want to get through this. Chloe Albert's Revenge, thank you so much. One crotch is the one on his head. The other is down below. They didn't fight for camera time, though. Okay. Thank you. Appreciate it. Okay. Okay, sorry. Another so they felt that she was not guilty on count 1, which was second-degree murder. And count 2 and count 3 leaving the scene with injury or death. It's interesting. So another day later, on July 3rd, 2024, attorney Yannetti was contacted by 2 different individuals, hereinafter informant B and informant C, who had received information. This is 3 jurors so far who had received information from 2 distinct jurors, hereinafter Juror B and Juror C, both of whom were part of the deliberating jury in this case. David Yannetti, informant B, sent affidavit 2. Informant B sent attorney Yannetti a screenshot he or she had received from someone hereinafter intermediary B of text messages that intermediary B had received from Juror B. In that screenshot, oh, okay, so it was an informant who got texts from a juror, okay, but received from Juror B. In that screenshot, Juror B texted the following to intermediary B. It was not guilty on second degree and split in half for the second charge. I thought the prosecution didn't prove the case. No one thought she hit him on purpose or even thought she hit him on purpose. Okay. Informant C had been in contact with another individual, intermediary C, who is a co-worker and friend of Juror C, and joined a Zoom meeting during which Juror C discussed the trial. Informant C sent attorney Yannetti the below screenshots of her text messages with intermediary C regarding what Juror C revealed in the Zoom meeting. Intermediary C, no consideration for murder 2, manslaughter. Started polling at 6-6, then ended deadlock at 4-no, 8 yes. Wow. Okay. Informant C, interesting. Oh, wait 1 second. And if I miss any of these guys, I do apologize because I'm on a different screen. I just happened to catch the color change because I have the chat on my phone, because it's easier to manage the chat from my phone if I need to. But if I miss one of these, I do apologize because I'll be reading. And I'm on a different page, as I said. It's just the color change on my phone gets my attention, and I can see that sometimes. Casey Crowell, thank you. Did you see the order of impoundment Bev just did? I screenshot it if you want. The order of impoundment? No, I have not seen that. Thank you. Sherry D, thank you so much. Where's Cherry? I think Cherry meant your audio is going to bust a speaker. Weird bass vibration coming through. We love Cherry. I don't know. Maybe there's something wrong with my maybe my mic. I can't hear what I sound like to you guys right now. There's really nothing I can do, and my audio was kind of acting up in its own weird way earlier, and I don't know what's wrong with it. And that's part of the reason why I was late, and I apologize. I was trying to get all this worked out. Now, so they were deadlocked at 4 no and 8 yes. Okay, and then Informant C says, interesting. If it was no consideration for murder 2, shouldn't she have been acquitted on that count and hung on the remaining charges? Go back to the jury verdict slip. That was all confusing. Right. So these are just common sense people right here. This is amazing. So let me finish this off. It says here she should have been acquitted. I agree. Yes. The remaining charges were what they were hung on, and the instruction paper was very confusing. So they were confused by the jury instructions. Wow. Okay. Well, no, see, that's the intermediary talking. Oh, no. Okay, never mind. No, this is wow. So this is a juror. Basically, wow, this is crazy. This is a juror basically confirming. Well, okay, no, this is still a hearsay. This is still somebody speaking for a juror. The instruction paper was very confusing, but that's not actually a juror that's saying that. That's not a juror in that text thread. So the argument here is the jury's unanimous conclusion that Miss Reed is not guilty on counts 1 and 3 constitutes an acquittal and precludes re-prosecution. I mean, exactly. What constitutes an acquittal is not to be controlled by the form of the action in question. Rather, the court must determine whether the action actually represents a resolution, correct or not, of some of all the factual elements of the offense charge. The mere presence or absence of check marks on a form is not dispositive. Wow. Here, the attached affidavits by attorneys Jackson and Yannetti reflect statements by 3 deliberating jurors that the jury had reached a final unanimous conclusion that Miss Reed was not guilty on counts 1 and 3. There was nothing tentative about the jurors' statements. To the contrary, they were definitive in describing the result of the jury's deliberations. Alan Jackson, juror A, was emphatic that count 1, second-degree murder, was off the table, and that all 12 of the jurors were in agreement that she was not guilty of such crime. David Yannetti, from juror B, it was not guilty on second degree. No one thought she hit him on purpose or even thought she hit him on purpose. Reflecting juror C's statement relayed by intermediary C, that there was no consideration for murder 2, and Miss Reed should have been acquitted on that count. To hold that this firm conclusion did not amount to an acquittal simply because it was not recorded in a verdict form would be to elevate form over substance in a manner prohibited by the foregoing United States Supreme Court and Supreme Judicial Court precedents. This makes this. I have question after question after question. I have one question ringing in my head, ringing and ringing and ringing in my head right now. But I'll probably forget it because I have to acknowledge the super chat. Thank you so much, Maniacal Miss. Can you please start over? I've just finished work and can't figure out what's gone on, or can tell it's a lot. Can I please start? Oh, okay. Maniacal Miss, as grateful as I am for your super chat, it's going to take a hell of a lot more than £5 to get me to make all of these people wait. The 2,234 in total wait for me to go over all of this all over again in order to help you. So I do apologize, but there is a rewind button. You can start the live over and you can see the train wreck that it was for getting started, and enjoy that as well. And then, or maybe speed it up. You can even speed it up and catch up to us. You could do that. There are many options, but I am not going to make all of these people wait just because someone came in late. It's not how it works. But I appreciate you, Maniacal Miss. Thank you. Yeah, exactly. Rewind and watch at like 1.5 speed or two times the speed. You can do that. It's absolutely an option. I'm not trying to be a dick. I'm just saying. I mean, I wouldn't have even read that out loud had you not put it in a super chat. Just say it. So, yeah, this is very, 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 very interesting to me because I had a question. What was my question? Am I going to remember my question? Let me find out if I can remember my question. Hold on. So, yes. Judge Bev argued over the confusion of this jury form, and it seems that jury form is exactly what confused the jury. It seems based on the behavior. Now, I'm not a lawyer, man. I'm not an attorney. I've never even worked in a courtroom on any level whatsoever. I've never even fucking cleaned a courtroom before, okay? I have no idea if this is true or not, but it feels kind of weird how Judge Bev was so argumentative about this thing, hoping that, it feels like it was something they were trying to just like slip past the defense. The jury question, the checkbox, and the way that it was worded and the way that it was worked out. I know, Maniacal Miss. Thank you. Doesn't it? I mean, it feels like it, and the fact that she argued about it and then reacted with such venom towards Karen Reed, directly towards Karen Reed, right after Yannetti shut her down, and she was like, "Right, Mr. Yannetti?" And Yannetti was like, no, Your Honor. No. I've never seen anything like that. No. and then she's like, "It's something funny, Miss Reed." Remember that? Now, that was a bit of a show. That was what we like to call courtroom drama, right? But it seems to kind of track a little bit now, doesn't it? Seems to kind of make sense. Seems a little bit more like Judge Bev. It was more than her just being in a bad mood that day. You know what I mean? Because now this motion to dismiss puts Bev in a spot. It puts Bev in a spot because she's already been dancing with the devil of violating constitutional rights. She's been waltzing around with the devil of violating constitutional rights. Just dancing. They haven't kissed on the dance floor. Yeah, maybe they kissed. But this is where Judge Bev would blatantly be putting the devil's dick in her mouth if she doesn't grant this dismissal. If she lets this go to trial after this, that's it. She is eating the devil's dick of violating constitutional rights. Not just state, but federal. Federal. I am so on the edge of my seat and interested to see what will happen here, because I can't see any way out of it for Judge Bev. I cannot see her not granting this dismissal, other than seeing her doing what she has done throughout the time I've been following this case. I'm going to keep reading this, but that's where I'm at so far. So, the statement relayed by intermediary C that there was no consideration for murder 2 and Miss Reed should have been acquitted on that count. To hold that this firm conclusion did not amount to an acquittal simply because it was not recorded in a verdict form would be to elevate form over substance in a manner prohibited by the foregoing United States Supreme Court and Supreme Judicial Court precedents. Wow. The Supreme Court's decision in Bluford is not to the contrary. There, a juror had reported during deliberations that the jury was unanimous against the charges of capital murder and first-degree murder, but split on manslaughter. The court sent the jury back to continue deliberations, and when the jury remained unable to reach a verdict, declared a mistrial. The Supreme Court rejected the defendant's argument that the double jeopardy clause prohibited re-prosecution for capital and first-degree murder. In doing so, the court relied heavily upon the lack of finality of the juror's report. The jury's deliberation had not yet concluded, and it went back to the jury room to deliberate further. Here, by contrast, the jury's statements reflect a final determination that persisted through the end of deliberations. Even assuming the contrary to the foregoing, this court finds that retrial would not be prohibited under Bluford. This court can and should afford border protection under Massachusetts state law. Wow. Okay, so this is interesting, folks. So that little section right there, again, not a lawyer, but how I'm reading that is basically Jackson and Yannetti and Little basically saying, hey, Judge Bev, you don't want to rule the wrong way here. This is their way of letting her know, not only that this is why they're filing the motion, but this is why it's a bad idea for her to rule against it and not grant this motion to dismiss. This is basically their very subtle yet respectful way of letting the court know, don't fuck this up. You can't afford to fuck this up. This is going to be real bad for you if you do. This is what's going to happen if you try to say that this is still going to go to trial. Don't do that. And Judge Bev doesn't like that. For the record, you can tell. Like, this is just, I mean, she already can't stand this defense. And what's really going to bother her is that they're smarter than she is. And as much as it bothers, and I'm just imagining here, this is just me speculating, but I imagine as much as it bothers, as much as I would imagine that it bothers Karen Reed's defense team, knowing what they know, dealing with what they've been dealing with in that courtroom from Judge Bev, as much as they can't stand having to kiss her ass and say things like her honor and with respect to this court. As much as I would imagine it bugs them to do that, because there's not a lot of room to respect that court. There just isn't. Not from what I've seen. I mean, so as much as there's that, I would imagine it bothers Judge Bev to realize that this defense team that she hates so much is smarter than her and is catching on to everything and calling her out on mistakes that she's making and doing it very publicly. I would imagine this is eating her alive. I would imagine that it's very difficult. If there's ever been a level of people having to maintain a certain decorum of professionalism, it's bugging these people. I'm talking about everyone on Karen Reed's defense team and Judge Beverly Cannoni. I think it's eating them alive, all of them, to have to be respectful to each other. I believe this because this is exactly, as much as I've titled this video and every other one, this is exactly how I titled this. And it is a sham. This is a gross and very public miscarriage of justice taking place right before our eyes. We're watching it happen in real time. We have been watching this happen in real time. Some of you for over a year. Me, only since late last fall, the earliest. This is insane. And it's gotten to a point now where the defense has, a wild card. It's done. Allison Faye, thank you so much. Bev has responded, and LTL posted it on his Twitter. Okay, yeah, no, thank you. And I think Cherry just sent it to me. She's yelling at me to check DMs. I'm imagining that's what that is. It fucking better be, Cherry, for your sake. No, I'm just kidding. Kidding. I would imagine that that's what it is. Let me go check real quick. Oh, there's an order of impoundment. Okay, cool. Yeah, I'll read that as soon as I'm done with this. Wow. Okay. This is going to be interesting. The Supreme Court rejected the defendant's blah, 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 blah. I think I read all that. Okay, yeah. Here, by contrast, the jurors' statements reflect a final determination that persisted through the end of deliberations. Even assuming arguendo, and contrary to the foregoing, this court finds that retrial would not be prohibited under Bluford. This court can and should afford broader protection under Massachusetts state law. Unlike the United States Constitution, the Massachusetts Declaration of Rights does not include a double jeopardy clause, but our statutory and common law have long embraced the same principles and protections. Reprosecution is, hold on a second. Let me see something real quick. Okay. I just wanted to see how much there was. Reprosecution is independently barred because there was no manifest necessity to declare a mistrial on counts on which the jury was unanimously agreed. Right. I feel like they should have been allowed to argue that. I thought that was shady too. I thought it was pretty shady that Judge Bev would not even give them an opportunity to argue the mistrial. I mean, I just kind of accepted it because I just figured, okay, well, that's her ruling and that's it. And we were all pretty tired, you know, and we all just kind of accepted it, right? We all just were kind of like, all right, well, you know, that's it, mistrial. And also because a lot of us expected it. Many of us were saying mistrial, mistrial, mistrial. This is what this is going to be. Judge Bev's going to call a mistrial. The jury can't reach a verdict. We all just accepted that was it. Nobody, or at least nobody in my chat, I wasn't, or at least I didn't notice, and I'm sure somebody probably did, maybe, pointed out, I mean, but I didn't even think to point out at the time until later that you know, it depends on what counts that they're at an impasse on, you know. But yeah, I mean, it's weird that so quickly Judge Bev just was like, all right, jurors, I'm excusing you. She didn't call for a recess or a sidebar or anything of that nature. She didn't say, is there anything the defense wants to add to this? Is there anything the prosecution wants to add to this? She didn't do any of that. She got the note from the jurors, and then she said, okay, jurors, at this point, I'm going to excuse you, and I'm declaring a mistrial. And that's it. And it was done and done. But it's true. The defense never had an opportunity to go, well, wait a minute. What counts? On which counts? Doesn't that matter? Everyone just kind of assumed. The double jeopardy clause affords a criminal defendant a valued right to have her trial completed by a particular tribunal. Thus, where a mistrial is entered without the defendant's request or consent, retrial is impermissible unless there was a manifest necessity for the mistrial. Wow. Okay. I mean, this is the law right here. This is double jeopardy law. Thus, where a mistrial is entered without the defendant's request or consent, retrial is impermissible unless there was a manifest necessity for the mistrial. So she absolutely abused her power there. Absolutely. That's insane.
I think we got a super chat. Super chat. I think we got a super chat. Super chat. Super chat. Super chat. I think we got a super chat.
Thank you so much, Helen Sacon. Today was a great day for Free Care and Read. Lizzie, are you still proud? You're the son-in-law my mother dreamed to have. Okay, thank you, Helen. I appreciate it. This is fucking wild, man. So, I mean, under federal law, like, she has to be able to, like, she can't just declare a mistrial without asking the defendant where they're at on that. This is wild. Now, the interesting thing about this is federal. So if she violated a federal law, right? Well, then this puts her subject to federal indictments. Now, if Josh Levy's office isn't already looking at her, they're looking at her now. They're watching this very move. This is it. If we're not aware of any federal laws that Judge Bev has violated, I mean, this is bad. She hasn't actually violated this yet. At least I don't know. I haven't read the impound yet. I haven't read what she filed yet. But this is crazy. This is crazy. Because I guarantee you that Josh Levy's office is looking at her right now. let's see. Okay, here Miss Reed did not consent to the declaration of a mistrial. See Alan Jackson's affidavit. See also Commonwealth versus Edwards. Rejecting argument that the defendant consented to the declaration of a mistrial because he did not object when the judge ordered the case dismissed. Absent the defendant's consent, state and federal double jeopardy protections bar. As a general rule, retrial of a defendant whose initial trial ends without a conviction. This rule is rooted in the importance to the defendant of being able once and for all to conclude her confrontation with society through the verdict of a tribunal she might believe to be favorably dismissed favorably disposed to her fate. Okay. I'm going to read that one more time. This rule is rooted in the importance to the defendant of being able once and for all to conclude her confrontation with society through the verdict of a tribunal she might believe to be favorably disposed to her fate. There it is. It's her right. It is her right. She has a right to not have society constantly going, hey, let's get her. On the same charges anyway. Thank you so much, Xander Ryan. Bet informant is the FBI. Called that shit. I don't know. Maybe, possibly. Thank you, Xander. I appreciate it. Before a court declares a mistrial for manifest necessity, counsel must have been given full opportunity to be heard, and the trial judge must have given careful consideration to the alternatives to a mistrial. Wow, which she didn't do. Clearly didn't do. Here, the defense respectfully submits that the lack of opportunity to be heard is alone dispositive. Upon receiving a jury note, the court declared a mistrial and excused the jury without consulting counsel. Alan J. Jackson affidavit. This action was sudden, brief, and unexpected, neither preceded nor accompanied by discussion with counsel. Meaning she never even addressing it with the defense. Finding no manifest necessity where no opportunity was given counsel to argue the propriety of the question of the necessity of a mistrial. Finding no manifest necessity where the trial judge first ruled that he was going to declare a mistrial, and then, almost as an afterthought, unenthusiastically asked whether counsel objected. The record is independently lacking on the second prong, as it reflects. Lynn, thank you so much for the Venmo. As it reflects no careful consideration of alternatives to a mistrial. Here, there was no obvious alternative. To simply ask the jury to specify the charges on which it was deadlocked. Had the court done so and the jury articulated its verdict consistent with the statements of juror A, B, and C, the double jeopardy implications would have been clear and decisive. Indeed, with virtual unanimity, the cases have applied collateral estoppel to bar the government from relitigating a question of fact that was determined in defendant's favor by a partial verdict. And they cite when the jury hands down a partial verdict, a final judgment is rendered on the counts upon which the jury has reached agreement. The Supreme Judicial Court's holding in Commonwealth versus Roth, blah, blah, blah. The court should not request partial verdicts on lesser included offenses charged in a single count does not pertain here. As the Roth court acknowledged, inquiry concerning partial verdicts on lesser included offenses that have not been separately charged carries a significant potential for coercion. Declining to require court to consider giving the jury new options for a verdict in the form of partial verdicts on lesser included offenses where, under Arkansas law, the jury's options were limited to two, either convict on one of those offenses or acquit on all. Such inquiry, in effect, implies that the jury should consider conviction on the lesser count. No similar danger is present, whereas here the jury was asked to return three separate verdicts on three separate counts, where a defendant has been charged in separate indictments or complaints, each with separate verdict slipped, with a separate verdict slip. Holy shit, man. That's crazy. And Neglected Mind, thank you so much. I hope people take their rose-colored glasses off. Beviant is done. Deviant is done. Oh, Beviant. Beviant. Ah, got it. Okay, cool. Excellent. Thank you. Appreciate it. Yeah, this is, I mean, I don't understand what's so hard to get here. This is some dirty, dirty shit. This isn't just a nice catch by the defense, right? This isn't just a nice catch by the defense. This is the defense doing like, this is the defense not just catching a technicality that they can use, you know, going, oh, wait a second, this isn't just that. This is them catching something that went seriously wrong with this trial. They're calling out Beverly Cannoni here for not even consulting, not even addressing, or even addressing the option for the defense to address her decision to call a mistrial here. They're calling her out on this. They're like, yo, Bev, what you pulled, you know, I'm not saying you were trying to be slick. I'm just saying that regardless of whether you were trying to be slick or not, we caught it, and this shit's not going to fly. That's basically what the defense is doing here. We're not saying you tried to pull a fast one here. That's for the public to decide. We're saying this shit's not going to fly. Alternatively, the defense is at least entitled to conduct post-verdict inquiry. Undersigned counsel did not initiate the communication with jurors A, B, and C, which resulted in the disclosure of the information that is memorialized in counsel's affidavits that are appended to this motion. Should this court find that further factual development is required, the defense respectfully requests that the court conduct a voir dire of the jury or an evidentiary hearing to substantiate the existence of an acquittal. Should the court seek the affidavit of each juror, the defendant asks the court to authorize undersigned counsel to initiate contact for the sole purpose of asking each juror whether the jury had unanimously agreed that the defendant was not guilty of counts 1 and 3. Now, this is interesting because what they're doing is it's almost like they're asking for a recount, but they're not. This is very, very important because it's not a question of a recount here. This is not putting the jury back in the deliberation room. That is not what this is. What this is getting them to testify, getting them to say that this is how I voted initially. Because for every one of those testimonies, there's 11 other witnesses, at least 11 other witnesses. See what I'm saying? So what they're doing here is saying, okay, well, we want at least, if you don't fucking dismiss this, if you don't dismiss those charges, then we want a voir dire of those jurors. We want a what was, sorry, I got distracted there for a second. This happens to be a lot, by the way. So they're saying we want a voir dire of those jurors, of each juror. We also want an evidentiary hearing. So I guarantee you that what we'll probably do, if she doesn't flat out just deny this, she's not going to, I mean, she's too goddamn proud to just go ahead and just dismiss those charges based on them filing this motion. She's not going to do that. What she's going to do is call a hearing to address this. That's what she's going to do. And then she's going to hear people, and then she's going to give the prosecution a chance to argue against it and oppose it. And then it's going to be a big show. But there's no way, based on everything that I've seen Judge Bev do, based on everything that I've seen, I have no reason to believe that she's just going to dismiss because they filed this motion and stated all these facts. I mean, this is going to be very, very interesting. But I guarantee you that she's either going to just flat out deny this, which I can't see how she could. I mean, because she's dancing with fucking breaking federal law here, violating someone's federal constitutional rights. This is, she's really dancing with that. So but it wouldn't really, it wouldn't surprise me if she did it. But if we're even thinking of getting her to dismiss those charges, you can count on an evidentiary hearing. You can absolutely count on a motion hearing, on a motions hearing. Absolutely. The Supreme Judicial Court has held that because of the importance of the issue, juror bias is a legitimate subject for post-verdict inquiry. It is similarly a fundamental tenet of our system of justice that a defendant may not be retried for a crime on which she was previously acquitted by a jury. And the defense submits that post-verdict inquiry is equally warranted in the present context at 790. Just as the court in McAllop approved questions to the existence of racial bias, questions about a matter more attenuated from the content of deliberations, whether the jury had unanimously concluded that Ms. Reed was not guilty of counts 1 and 3, do not invade the heartland of jury deliberations, but preserve the defendant's precious rights to the favorable outcome of a jury trial and to the protections of the double jeopardy clause and its related state judicial protections. Conclusion: for the foregoing reasons, Ms. Reed requests the Honorable Court issue the order dismissing counts 1 and 3. Okay, yeah, and this is all just the formalities here, but hold on. This is the, okay, this is Yanetti's affidavit to support the defendant's motion to dismiss. On January, I just skipped to the parts where on July 3rd, 2024, I received communications from two different individuals, hereinafter informant B and informant C, who had received information from two distinct jurors, hereinafter juror B and juror C, both of whom were part of the deliberating jury in this case. To my knowledge, informant B and informant C do not know each other. On July 3rd, 2024, informant B sent me a screenshot she had received from someone hereinafter intermediary B of text messages that intermediary B had received from juror B. In that screenshot, juror B texted the following to intermediary B: It was not guilty on second degree. It split in half of the second charge. When the judge sent us back with the Hernandez sick thing to look at the other side, it turned into a bully match. What? I thought the prosecution didn't prove the case. No one thought she hit him on purpose or even thought she hit him on purpose. They gave us free counseling forms when we left. Based upon the first name of Juror B given to me by informant B, I believe I am able to positively identify which juror he or she was and confirm that he or she was a deliberating juror. Wow. Okay. This is crazy. So that juror was like, nobody thought that she hit him on purpose. July 3rd, 2024, informant C contacted me to say that he or she personally knows Juror C and they used to work together. Informant C and Juror C also have a mutual friend, hereinafter intermediary C, who is current co-worker and friend of Juror C. Informant C told me that she had posted something about Karen Reed case on Facebook on Monday, July 1st, 2024. She told me that she believes that post led intermediary C to text her and inform her that Juror C was a deliberating juror on this case. Informant C told me that he or she thereafter reached out to Juror C via text message and discussed his or her experience as a juror in very general terms. They discussed what an exhausting experience it was, and that Juror C was relieved that it was finally over. Intermediary C told Informant C that Juror C would be participating in a Zoom meeting with a number of friends to discuss what happened with the trial. Today, Informant C sent me 3 screenshots of a text message exchange he or she had with Intermediary C. Informant C told me that Intermediary C was reporting to her during the exchange what Juror C had revealed during the Zoom meeting. The text message exchange reads as follows. Intermediary C, no consideration for murder 2. Manslaughter stayed polling at 6 and 6, then ended deadlock at 4 no, 8 yes. Wow. He or she was very consistent in the fact that they could only consider things that were admitted into evidence. Ultimately, he or she voted no because the cause of death was twofold of hypothermia and head injury, of which he or she was convinced that the vehicle did not cause both. Wow. The whole jury felt intimidated by Higgins' presence at the end. Wow, dude. Wow. Dude, that's crazy. When did I fucking miss that? When did Higgins show up to court? Are they talking about when he testified, or did he sit there was he there during any deliberations or during, that's what I was thinking. Okay, thank you guys. I think that they were mistaken okay, then that fucking confirms, people. How many times did you hear me say that shit? What other purpose could those 4 people that were sitting behind John or Paul O'Keefe in that courtroom, what other purpose could they have served other than to intimidate the jury? And here the jury is confirming that they felt intimidated by Brian Albert's presence in that courtroom. They stated it. They said it. This isn't theory anymore, folks. Bong dong want, bro. Okay, right now, first of all, you win handle of the day, okay? I mean, handle of the day in a landslide. I think Glare could have gotten Karen off with an innocent verdict using a 6th grade education. Jackson and Yannetti owe her a partial refund. Fantastic. You also win Burn of the Day. That was amazing. Thank you so much for that. I appreciate it. What's up, Mazamedia? It's good to see you, buddy. So, dude, I'm trying to tell y'all, dude, what other purpose could Brian Albert's presence that day, sitting in that gallery, that day of all days, what other purpose could that have been for? What could it have served? I mean, again, it's no longer theory, folks. And by the way, 6th grade education got it right, by the way. Okay? Let me, real quick, let me give myself a round of applause. Thank you. Yo, who's got 2 thumbs, a 6th grade education, and called that shit? This fucking guy. I mean, people. I mean, what else do you need? What else do you need? They weren't there for sympathy. Those people just admitted that they were intimidated by Brian Albert. Think about that. They just admitted that they were intimidated by Brian Albert. I wonder how much else that had, how much more influence that had over the jury's decisions, over the jury's deliberations. How much of that? Because again, I'm sticking to it, folks. I'm sticking to it. I'm sticking to my original point, my original theory that the only reason that I can imagine why this jury would not be unanimously down the board, across the board, right? Unanimously not guilty on all 3 counts. It's the only reason is because they're scared of the McAlberts. Chloe Albert's revenge. Thank you. I've been saying the dude looks like Thanos. He does. He does. Yeah. What other fucking logical reason would there be? This is a smart bunch. I saw this jury myself. I'm telling you right now, they were all attentive. They were taking notes. They were reacting. They were reacting to shit that made it. I mean, I'm talking about the defense did an incredible job of painting a picture here of there being a third party culprit. And there is nothing redeeming or innocent looking about Brian Albert at all. About his testimony, about Colin Albert's testimony, about Jen McCabe's testimony. All of it was fucked up. All of it. Matt McCabe's testimony, all of it was fucked up. There's so much doubt. I mean, the very fact there's such an ironic thing when you think about it, because the very fact that the Alberts, the very fact that that Brian Albert intimidated this jury by his mere presence tells you that by default they had doubt in Karen Reed's guilt. They had doubt in Karen Reed's guilt by default if they already were intimidated by Brian Albert's presence in the courtroom. Because if they actually thought that this conspiracy theory thing was absolutely crazy, if they actually thought that Brian Albert was just an innocent ex-cop doing his thing, if they honestly believed that, they wouldn't have any reason to feel intimidated by him. This is, I'm telling you folks, the only fucking reason that shit was not unanimous down across the board, not guilty, the only reason that is because people were intimidated by Brian Albert. If this jury was intimidated by Brian Albert, that means that they did not believe that Karen Reed actually hit John O'Keefe with her vehicle. There's no way that they believe that, especially with the two ARCA experts that testified. The crash daddies, as you guys like to refer to them as, with their testimony, there's no fucking way that anybody believed that Karen Reed even hit him with her car. They were willing to compromise out of fear. They were willing to compromise the facts out of fear of Brian Albert. It says so right there. It says so. It's there. It's in fucking text writing. People, this is outrageous, man. Fucking outrageous. Christy, thank you so much. Hate spoiled it earlier, but told you all about the intimidation fuckery from that juror. Yeah. No, I appreciate it. This is fucking wild. He or she, not sure what she's going to do. She's going to lay low for a couple of days and see where it takes him or her. Hasn't ruled out anything. The jurors all have a group text going. Interesting. If it was no consideration for murder too, shouldn't she have been acquitted on that count and hung on the remaining charges? Go back to the jury verdict, or charges goes back to the jury verdict. Slip that was all confusing. It goes back to the jury verdict slip that was all confusing. Wow, that's crazy. So that right there, the way that Judge Bev was so fucking combative towards the defense when they brought up this questionnaire, when they brought this up, that jury slip, Judge Bev being so combative, it makes her look real bad, which adds to the impact of what her decision would be here. I mean, this is fucking crazy, dude. So right here, they're confirming two things: that the jury slip was confusing. They're confirming that, and they're confirming that they were intimidated by Brian Albert's presence in the courtroom. Fucking wild, dude. She should be acquitted. I agree. Yes, the remaining charges were what they were hung on, and that instruction paper was very confusing. What a great experience for him or her. Amazing that they let the Alberta in the last day. I guess they're okay. Amazing that they let the Albert in the last day. He or she felt very honored to be part of it. He or she was okay, blah, blah, blah. Everybody else was from a professional walk of life. They all got along and never heated. They agreed to disagree and respected each other. That's the way it should be. Knew it was an intelligent jury. There we go. They will be studying this case in law programs for years to come. Right. How not to investigate and try a case. Wow. If they all agreed on no for murder too, they should make it clear. They should make that clear to the DA and the court. It's basically a case of double jeopardy if she is retried on that charge. Based upon the description of Juror C given to me by Informant C and confirmed by the redacted content of the above text message exchange, I am able to positively identify which juror he or she was and confirm that he or she was a deliberating juror. This is fucking crazy, dude. I mean, what other shit? I mean, these are just pure fucking shenanigans, people. How are these not just pure fucking shenanigans? You know? I haven't even gotten into Judge Bev's, what she filed. This is fucking the most insane shit I've ever seen in my life. All right, let's check this out real quick. So this is an order of impoundment. And excuse me, guys, like as hard as it was for me to read already, this is going to be more difficult because this is a screenshot of this order, and it is I can't really zoom in on it. Maybe, yeah, I can a little bit. The Supreme Judicial Court has recognized that the safety of jurors is crucial to the fair functioning of the judicial system, and that the justice system owes them the highest degree of vigilance for their personal safety. This case has garnered significant and decisive attention in Massachusetts and across the nation. The trial was live streamed on local and national broadcasting channels. The proceedings continue to be the daily subject of commentary in various social media platforms. Holla! People associated with that case have been charged with intimidation. Oh God! This court acknowledges that the names of impaneled jurors who rendered a verdict in criminal case must be retained to the court file and available to the public. Okay, so this. Okay, I'll just keep reading it, but. The jury in this case did not render a verdict. However, the court concludes that there is a real and present risk of personal harm to the jurors and to the integrity of their service. Consequently, the court finds that good cause exists to impound the list identifying the names of impaneled jurors in the trial of this case. Hold on a second. The court concludes. I mean, yeah, I'll share it, but there's no need. It's just a couple of lines here. The court concludes that there's a risk of immediate and irreparable injury should the list be made. There is a risk of immediate and irreparable injury should the list be made available to the public at this time. See Uniform Rules of Impoundment, blah, 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 blah. This order shall expire 10 days from the date of issuance unless otherwise ordered by the court for good cause shown pursuant, blah, 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 the Uniform Rules of Impoundment Procedure. Okay, so she's basically saying that not to release the list of jurors. Basically, don't dox the jurors, which is fine. That's great. I have no need of knowing who any of these jurors are, and especially, and this, I agree with Judge Bev's motion here. Personally, I agree with Judge Bev's motion here because I want these jurors to be able to make it to have to testify in a voir dire if they need to. I want these jurors to be able to have to testify in a deposition if they need to. I need these jurors to be okay, each one of them. And the only people that would have any interest in hurting any of these jurors would be the people that would actually be implicated of John O'Keefe's murder if provided Karen Reed is exonerated. So I absolutely and totally am all for the protection of the identities of these jurors. Personally, I am. That is my personal opinion and my personal stance on that. I am glad that she's doing that because I believe if they felt intimidated by the Alberts, they should be protected from the Alberts as best as possible. And they should absolutely be protected because considering who were there to intimidate and the reach that they have, who was there to intimidate and the reach that they have, I mean, look at what they're doing right now. They're absolutely using the law to railroad an innocent woman in order to keep the heat off of themselves. This is exactly, in summary, what is going on right now, folks. What is going on right now are the very people who are actually responsible for the murder of John O'Keefe, Boston police officer, John O'Keefe. Those that are actually responsible have managed to orchestrate a sham of a prosecution. They've managed to puppet string a sham of a prosecution against an innocent woman. Imagine what their reach is and what they're capable of. I absolutely 100% support the protection of the identities of these jurors until this is all worked out, at least until this is all worked out. Because I got to tell you, Proctor's missing paycheck sent me sent me a cash app for dog treats. Thank you so much. Proctor's missing paycheck. It went to my cash app. Thank you so much, or at least a small fraction of it. I'll take it. Clubber will take it. Yeah, that's what I was gonna say. Did I miss that? Because guys, I miss shit all the time. You know what I mean? I gotta tell you my train of thought there. When I was asking, did I miss something? I was preparing myself mentally for looking like a complete and utter fucking ignorant jackass that Higgins showed up at one of the final days of trial and I missed it. And it just completely went under my radar, even though I streamed it. I was willing to entertain that possibility. That's how fucking fried my brain is. Okay? That's how fucking dumb I am. All right? I was actually willing to, I was like, shit. I was like, fuck, man, this is going to be embarrassing. This is going to be a big fat turd I'm going to have to eat right here in front of everybody that Higgins was there and I didn't even fucking catch it. But you guys confirmed that it was this person misspoke and they were actually talking about Brian Albert, because two meathead Bryans who like to play grab ass with each other are easily confused with each other. It's an honest mistake. It's an absolute honest mistake. Yeah, I am absolutely of the opinion at this point, folks. You guys watch me because you know I like to keep things simple, and I say things how it is. And to put it as simply as possible, I am absolutely now, without a doubt, I considered it a possibility before. It was just a theory before. Now I am convinced that the only reason that Karen Reed did not walk absolutely acquitted of all those charges is because of the intimidation capabilities of the Alberts and the McCabe's. Absolutely, specifically the Alberts. Their ability to intimidate. Everyone knows them there. Everyone knows who they are. This absolutely confirms that for me. And I find it fascinating. I mean, and it's really funny because this is where things started to get dirty, right? Like Twitter, man, people are really getting upset about me having a voice here. My channel's already been reported. Like they're going through old videos right now of mine and trying to report them. They're doxing me on Twitter, spreading lies about my past. And my past is my past. There are things that I've done that I'm not proud of, but get them right. There's certain, it's not good enough that I'll come clean about certain things about my past. It's not good enough that they go, oh, well, fuck. Okay, well, we're just going to have to make some shit up now. And that's nothing. This is fucking, this is controversial. This is every controversial case for me. I've been on YouTube for years, dude. Like, this isn't the first time. That's why it doesn't faze me, is because it's like, okay, you think you're the first? My channel does nothing but grow. You think anybody gives a fuck about these things that you're saying? Look at where they're coming from. Because this is the thing that these people don't understand. Nobody's listening to you. Plevins and Kate Peter and all of you fucking jackasses out there. Dick Tracer, whatever the fuck your name is on Twitter. Nobody gives a fuck what you have to say, because the thing is you already don't have facts on your side. You can make up all the shit that you want about anybody, but it's not going to change the fact that you have to resort to hanging turtles on people's properties. You have to resort to these tactics. You're not going to change anyone's perspective here because the truth is on our side. And you're not going to intimidate anyone at this point. Nobody. I mean, that's it. You've already played your last cards. You're done. At this point, it's just going to be making fun of you. Because, I mean, you want to get childish with somebody who prides themselves on being fucking childish, but I won't go low. I won't do that. I won't go and dox you, and I won't go and take your past and judge your character on it, and unless it applies to your current character, that's a little different. But if you want to get childish with somebody who prides themselves on being childish, well, then I'm happy to do it, because I could always use content. It's fun. I'm petty like that. I don't give a fuck. I'm not above going through people's shit and laughing at them. Lord knows, all of you people out here know I'm not above that. I mean, so you can sit here with your little attempt at a smear campaign because you think this is going to go to trial again, and you think it's going to win support on the McAlbert's favor. It's not. It's not. Because the truth always prevails. Always prevails. See, this is why I'm a thorn in their side, folks listening. This is why I'm a thorn in people like their side, because I have facts, indisputable facts, the truth, along with the inclination to be a petty, childish douche. I love that shit. It's fun. It's so much fun. It's so much fun to be able to be a childish douche, but to be validated constantly by the truth. It's fun. It's fun. I get to be up here and I get to make fun of you for being cunts. The lot of you for being cunts. I'm talking all the way from the producers at Court TV down to the fucking plebins. I enjoy it. I enjoy it because I could be a childish, complete and utter douchebag. And these people are always going to enjoy it because I have the truth validating me. And it's constant. It never stops, dude. It never stops. It's fucking wonderful. I mean, I could do it right now. I mean, let's take a look just for fun. I mean, who knows? I would be reacting to this, but just for fun, let's take a look at some court TV. Because I'm curious as to what court TV is saying about all this. Considering where our minds are at now, I'm dying to know. Maybe court TV will pleasantly surprise me. I'm hoping for that, actually. I'm hoping that I don't have to be a childish douchebag on here. But let's see.
Welcome back to Court TV Live. I'm Ted Rollins outside the courthouse in Santa Fe, New Mexico, covering the Alec Baldwin case. But we want to switch gears momentarily here for some breaking news out of New England in the state of Massachusetts in the case of Karen Reed, the one we just finished up here on Court TV. The defense has filed a motion asking for 2 of the top charges against Karen Reed to be thrown out. And the reason they are asking it in this motion that they filed is because it has come to their attention that the jury had a firm 12-0 agreement that Reed was not guilty of 2 of the 3 charges against her, including that top charge of second-degree murder. According to Alan Jackson and David Yannetti, the lawyers, of course, representing Karen Reed, who filed this motion, they say that jurors got a hold of them after hearing reports about the supposed juror split. We've heard all kinds of things. If you've been on social media, people are saying, oh, it was, 6-6, or it was this, that. They're saying that jurors reached out to them and that the jury had unanimous verdicts of 12-0 on the top 2 charges. But apparently what I'm reading here is they didn't put it together that they could have come back with those verdicts and said not guilty, and hung on that 3rd count. Let's bring in Jessica Ehrlich to discuss this. This is interesting, Jessica, because,
I mean, how did that fly under everyone's fucking radar, man? That's what I'm trying to understand. How did that fly under everyone's radar? Everybody just took Judge Bev's mistrial like, okay, there it is. It's over. I guess we'll be here again in a few months, right? Holy shit, an eclectic mind gifted 20 memberships. Oh my God, that's fucking amazing. Thank you so much. Wow, that's fantastic. I appreciate that. Thank you. Yeah, that sounds like I'm gonna have to do another members only live coming up soon. Sounds like we might have to do that. Congrats to all you guys that got memberships. That's awesome.
We got the jury coming into the courtroom saying we are undecided. We can't come to a unanimous decision if this is true. Does the defense have a solid motion here to basically dismiss these charges? Because if indeed the jury was in agreement 12-0, they effectively came to a verdict on those top 2 charges.
Yes, I mean, I'm dying to get my hands on their motion because I would really like to see, from a legal analysis standpoint, if there are precedents in the state of Massachusetts that they're able to cite to in this matter. I mean, it's certainly from a public policy standpoint, we know that, for all courts across the country, you always want to have, especially after a lengthy trial like this, and it's been to the jury, it behooves everyone, and it is sort of the public policy standpoint that you want the jury to at least come back on 1 or 2 of the issues if so that to avoid a mistrial. You really want to do everything you can to avoid the situation that we had here when they had a hung jury. So I definitely think from that standpoint, it's a very strong argument to make. The question is, you know, in terms of Massachusetts, will the judge be able to call the jury back and feel that, you know, they're able to take this vote given everything that's happened since they were dismissed? So it will be very interesting to see.
See, I have a question for like the Betteros and Littles and Bakers and Runkles of YouTube. I have a question. Can Judge Bev be federally indicted for denying this motion and letting this go to another trial under those same charges? Can she be federally indicted for this? I don't know if she can, but I'd really like to know. That's something I'd like to pick the brain of an attorney.
Definitely quite a turn of events here. I mean, we've been following this for a long time, as you know, and it is fascinating and actually does not surprise me at all that the jury did have very strong opinions about those first two. And you and I were talking when remember, there were so many issues with the jury instruction.
Okay. Oh, you thought I forgot, huh?
I think we got a super chat. Super fan. I think we got a super chat. Super fan. Super chat. Super fan. I think we got a super chat. I think we got a super chat.
Maniacal Miss, thank you so much. Your channel and subs chat are the best. I'm here for it and couldn't give a flying fuck about the past. We all have one, right? Thank you so much. I appreciate that. That really means a lot, man. And yeah, man, big shout out to some of those people on Twitter, man, that you know, said basically the same things, man, in response. Like, I mean, they don't realize how stupid they look by you know, just attacking and lying on people, you know, like they don't understand, you know, like, and they do it to like really decent people, you know, they did it to like Melanie Little to the point to where she left fucking Twitter. They do it to Brandy Churchwell. I mean, can you think of a nicer person to do that shit to? Like, that shit is crazy. I mean, so it's not even a question. There's not even a justification, folks, of oh, thank you, Lynn, so much. I appreciate you for the Venmo. There's not even like there's not even a question that like there's no argument to the only person who even attempts to put up an argument about the death of John O'Keefe is Plevin. The rest of them, all they do is attack and insult and lie. I mean, it's insane. And for some reason, they think that this is going to, in some way, make their point more valid and shift people. They think that finding out that I admitted to a private incident in my family is going to make people feel differently about Karen Reed's innocence or guilt is mind-blowing. It just says all it does is speak volumes on you. To think that lying about inappropriate relations between a YouTuber and an attorney, you know, they think that is going to make people, you know, taking trips to fucking Cancun and shit. They think that making things up like that about people is going to shift people's opinion on the facts that everybody is, this is the one thing that's tying us all together. The one thing that's tying me and everybody in this chat together right now is the truth. That is the one thing that's tying us all together. It's not Karen Reed herself. It's not Turtle Boy. It's the fact that we all have a wonderful, beautiful love affair with the truth. We have that in common. It's almost like I said, you guys like to call us cult members. There is a cult. There is a church. That church is the truth. And we all come together to congregate and celebrate the truth. It's what we all do. We get together, we congregate, and we celebrate the truth. It is the most powerful thing that drives me with this channel. The truth alone. I'm constantly seeking it. I'm doing my best with my very, very limited education that is pointed out so often. But I have that. I have that in common with people with PhDs. I have that in common with all different shapes and sizes of people. And that's something that you're never going to deviate. You're never going to deflect that. You're never going to get in between our love affair with the truth. It's never going to happen. You could just sit in the corner of the junior high school dance where nobody wants to dance with you, and you can watch the rest of us having makeout sessions in the corner with the truth because the chaperone is shagging the English teacher up in the classroom on the second floor. That's all you're doing. You're just sitting there wallflowers, hating, being jealous of those of us who are having makeout sessions with the truth on a constant basis. Hitting second base, bro. You know what I mean? With Lady Liberty. There's nothing you can do about it. There's fucking nothing you can do about it. And Eclectic Mind, thank you again. Had Twitter for about a week that said, hell, I have time for this game. Taking my ball and going home. I don't blame you. I don't blame anybody for that shit. I don't blame anybody for that shit.
Instructions in this case, that we knew that something was going to happen for sure. I mean, this was just very confusing for the jury. They had to redo the forms. So really, I'm not surprised that the jury came back on this. And it's very interesting that the jury actually reached out to the defense on this. I'm also curious as to how that transpired and what was going on there, that conversation was had.
And there has been so much misinformation because of the interest levels and the different bloggers that have jumped into this full force. It'd be, in terms of a remedy here, if the court really wants to find out, you don't just go by what the defense says, obviously, and you can't really just go by with what 1, 2, 3, or 4 of the jurors told the defense. Great. Juror number 4 believes that it was 12-0. Don't you have to, doesn't the court have to do a full investigation and contact all 12 of those sitting jurors to validate this claim from the defense and then make a decision after establishing that this is in fact true?
Well, it'll be interesting to see how they, wrote their argument. I think certainly the judge would speak with the foreman, because really the foreman is supposed to be the spokesperson for the entire jury. So if the judge speaks to the foreman, if they even go that far, I mean, I don't know that it's really a matter of saying, is what the defense saying true? It's also a procedural thing. Can they even bring the jury back after they've been dismissed? Would this even be allowed from a just, jurisprudence, procedural Massachusetts law standpoint, to even whether the judge would be able to interact with the jurors?
Now, how much you all want to bet that Vinnie Politan is going to go live on his channel at some point today? Most likely, at some point today. Go live on his channel, and then somebody is going to super chat him a question and ask him, hey, do you think that Judge Bev did this on purpose? Do you think that Judge Bev was aware of what was going on here and called this mistrial without any without discussing it with the defense, giving them an opportunity to argue against it? And then Vinny is just going to go, do I think Judge Beverly Cannoni did so knowingly? Ooh, that's a tough one, because, I sit here and I got a TV show, and I'm in this really, really tough position to have to really, I got to weigh these things. And, dude, and he's not going to say a fucking thing. He's going to avoid it. He's not going to say shit. He's going to completely fucking avoid it. He's going to dance around the shit. And it's just going to frustrate everybody. And then everybody's just going to keep giving him money, because he's Vinnie Politan. Hey, forget about it. Vinny, forget about it, Politan. That's what's going to happen.
On that matter, whether the court would, this is a very unusual situation, but I would say definitely they would start with the foreman, because the foreman is supposed to be the spokesperson of the entire jury body. They were elected by the jury, and they should be able to sort of speak to that. Now, I don't know whether in the motion the defense spoke to the foreman, and the foreman was the person who said we had a unanimous decision on the first two counts, but could not go further, and didn't realize and didn't understand that that was possible for us to make a decision on, because also there should be notes and everything kept by the foreman as to what actually transpired. It's just a very, very unusual and difficult situation. I can see why, from a public policy standpoint, it is what you want to avoid, having to do this entire enormous trial over again on all counts. But I don't
think that he has me blocked yet, little Irish girl. In all honesty, I haven't been in his chat in a minute, and I've given him a few super chats, and that comes straight from experience. Lori, thank you so much for the Venmo. I have super chatted Vinny to corner him into answering a question, because he likes to do it. I will give Vinny that much, because there's a lot of bigger YouTube creators that don't have, they don't even address the super chats. And sometimes it's really difficult because the chat's going so fast and there's a lot of them. So I understand that to some degree, but I will give Vinny credit that he likes to address all the super chats. And I super chatted him. I don't even remember what the questions were. And I'm telling you out of experience, this is what he does. Because I try to ask him questions. I see that he's on the fence about shit. And I see the shit that Julie Grant's fucking saying. And I'm like, dude, you're representing court TV, bro. I could tell that Vinny thinks that Karen Reed is innocent. I can absolutely tell Like, I can tell personally, I can tell that Vinnie Politan believes that Karen Reed is absolutely innocent of this crime. But he won't just say that. He won't just say that. Because it's not in his contract. Or something. I don't fucking know. But it's a court TV thing. It's totally a court TV thing, you know? But it's so frustrating. Like, because I'm not really fair to Vinny, you know? Because, like, I expect Vinnie Politan to just be like, fuck my job. This is wrong. You know what I mean? Which is just unrealistic. I don't expect Vinnie Politan to do that. Robert, thank you for the Cash App. I appreciate you, buddy. You know, it's unrealistic to expect Vinnie Politan to be like, fuck my producers. This is what I think. This is my fucking YouTube channel, and I'm telling y'all what I think. I'm sick of this bullshit, and I'm sick of fucking acting like and getting all the shit from people saying that I don't care enough about justice. Blah blah blah. Tired of this. Fuck my job. Karen Reed is innocent. Like, that's just never gonna happen. It's just never gonna happen. You know. So, but you know, Vinny. You're gonna be subject to that criticism, bro. If you're gonna be such a bad actor to where like we could tell that you think Karen Reed's innocent, and then sit here and act like you're on the fence about it, like you're people with common sense are gonna call you out on it, and it's just how it is, dude. And I think he understands that. He gets. He's a public figure. He understands.
I'm dying to read.
But was it really a verdict if they told the judge that they could not come to a verdict? Was it a verdict? You know, they may, you know, if what they're saying is true, if what the defense, what they got from these jurors is true, that they all agreed 12-0, all right, definitely not murder too. Definitely not intoxicated leaving the scene of the accident. Then they should have put that down on the verdict form, and that those were verdicts, correct? And that's a mistake possibly from this jury. But how do you remedy that?
I mean, I think that is the ultimate question. And it's certainly going to be a matter of law and precedent. I'm not sure that there's a lot of precedent in Massachusetts that I'm aware of that would actually give the judge a lot of room here in terms of where to go. I mean, I know even with some of the issues with the form, it was unlikely that they were going to change the form. Then she reviewed the various arguments and came back. So this is really sort of one of those arguments. Certainly, even if the judge says no, the jury was dismissed, this is something that, you know, they can try to bring up, I think, you know, in their appeals and in everything else, that this was, you know, a tainted trial from the get-go, and especially given the fact that the jury was confused as to what their instructions were. We know that there was confusion around what the form was, and that led to the situation that they were in, and therefore it should be, you know, tossed out. So I mean, this is going to be a really interesting, I'm dying to hear the arguments on this.
Yeah, and just reading parts of this motion, it's not clear that they have definitive evidence. They're getting it from a juror that reached out after seeing inaccurate reports in the media about the split. And there needs to be, one would think, more investigation before a judge can do it. There's Judge Ashley Wilcott. She knows what to do in a situation like this. First of all, Judge, your initial thoughts reading this motion. Wow. What should be done here?
Well, first of all, the right thing to do by the defense is to file a motion like this if they have information to believe it's true. But Ted, can I just tell you, the thing that bothered me the most at the end of this trial was nobody asked to poll the jury. This, from a judicial perspective, is why you have to ask to poll a jury, because if they'd done that, they would have known right then and there to figure out what to do next if, in fact, 12 said not guilty of the higher charge. So I don't know the law. I haven't yet had a chance to look at the state law and this state case law, but I would want to look at, if you don't poll the jury, do you waive any right to raise it down the road? You might. So there are a lot of legal issues. But again, all I could say is, why in the world would you not?
Wait. Okay, hold on a second, because I'm like, what? Yeah, that's super weird.
A judicial perspective is why you have to ask to poll a jury, because if they'd done that, they would have known right then and there to figure out what to do next if in fact 12 said not guilty of the higher charge. So I don't know the law. I haven't yet had a chance to look at the state law and this state case law, but I would want to look at, if you don't poll the jury, do you waive any right to raise it down the road? You might. So there are a lot of legal.
See, I wonder if polling the jury, because apparently they don't poll juries in Massachusetts, but I'm wondering if there's an option to. I wonder, like, can the defense file a motion for the jury to poll? Could they have done that? Is there a possibility of polling the jury at all, is what I'm curious about. Right, Calamity Jade, that's what I'm getting at, is she admits in this person's defense, she admits that she has to look at the state law in regards to polling the jury. And so I'm curious to find out exactly in detail what polling the jury, what polling the jury statutes there are. So it's interesting to me, but I mean, I'm wondering if they could have polled the jury, and I'm wondering if, since they can't poll the jury, is that a loophole, or is that some sort of loophole where Judge Bev gets to actually just declare a mistrial? But I just don't see how that. I don't see how she can do that. I don't see how polling the jury would be relevant in the argument that the defense has, that they did not get a chance to argue against the mistrial. That they weren't given an opportunity to speak on it, that the defendant did not get an opportunity to object to it. So that's interesting to me. I don't see how polling the jury would be relevant to that. So there's that. At the end of the day, you still have to do it. And they cited Massachusetts law in the motion to dismiss. They cited Massachusetts law as to why Judge Bev needed to be able to hear the defense and give them an opportunity to argue against the mistrial. But it's just, I'm still blown away by the fact that this went under everyone's radar. Even all the law tubers, as I understand it, this went under everyone's radar. That nobody was like, well, I mean, why didn't the defense argue the specific charges? Why don't we have the mistrial and the details of the mistrial based on the specificity of each charge? So I got a lot of questions.
Legal issues, but again, all I can say is, why in the world would you not?
Okay, thank you, good citizen.
A jury to address this at the time it was happening.
And normally, when a jury comes back and they cannot come to a decision, a mistrial is declared. It's not, on the record in the courtroom polling. What'd you think? What'd you think? What'd you think? Because it's a mistrial. But
also, folks, you got to keep in mind, it's now undeniable that the jury slip that the defense argued against, the wording of it, the way it was set up, saying that it would be confusing to the jury. Bev was like, nope, that's just how it is here in Massachusetts, right, Mr. Unetti? And Mr. Unetti was like, no, Your Honor. That's one of my favorite moments, if you haven't noticed, by the way, is her like going trying to get some sort of validation from David Yannetti, and Yannetti being like, yeah, I know, Your Honor. That's just my favorite. I love it. So, that now that we have confirmation, we have fucking specific confirmation that this was an issue, that this was a problem with the jury, that it raised confusion. So one could absolutely argue that the purpose of the way it was set up was to confuse the jury. I mean, one could argue that. It's not inconceivable. One could argue that the purpose of it was to absolutely confuse the jury. And Bev was so fucking protective of it. It was so weird.
To your point, typically, after the dust settles and both sides want to know what the split is, right? Especially the prosecution. Are you going to retry this case? Well, how about finding out what the split is? And it doesn't seem as though that was done. And now we're in a position where...
Amazing. A court TV correspondent who I've never seen before, because I don't watch that much court TV, but is actually speaking some fucking logic here. He seems to be thinking out loud in pursuit for the truth. I love it.
You have a juror contacting the defense saying, I was watching the TV and they had it wrong, or I was on social media. That wasn't the split. Jessica, does it, again, do you have to do a full investigation before you can even think about another step? Because if this isn't accurate, well, then there is no next step. But if it is, boy, it's a head scratcher.
I mean, I think, and to the judge's point and what you were saying a little bit earlier, to loop on that as well, one of the reasons you're polling the jury afterwards too, from being the advocate standpoint, is what are your arguments that landed well and where were there maybe missteps? So if you do have to retry this case, to improve, to tighten, all of those sorts of things, where the holes are, not to mention the situation that you're in now. So certainly, again, I have to go back to the foreman of whoever this is. We don't know. I haven't looked at the motion yet to see who it was. You can't make legal decisions based on what is complete hearsay and gossip, right? We know this in general. However, there are, and certainly, I think the judge will be aware, the larger argument here, I don't see a way that they would necessarily reach out to every single juror before they make a ruling on this motion to say whether that is true or false. The question would be, I think put to the foreman at first of, did this situation occur? Was there a vote on this count? And then it was unanimous. Was there a vote on this count? Where are the records of that? Where is everything of what, that they had as to what they actually voted on, and to how they interpreted and how the foreman interpreted the form at the time?
Judge Ashley, your thoughts on that and what you think should be done now at this point. And another question for you, isn't it up to the judge at the end of the day to have gotten this information to facilitate the conversation between the parties and the jurors after a mistrial was granted?
Yeah, well, I just wanted to comment on that. Ted, as the judge, honestly, you always have to look at the verdict form to make certain that it is correct in terms of how it's filled out. So arguably, this judge knew that it was 12-0. If in fact it was, we don't know confirmation of that. We just know that's what's in the motion that a juror has said. But the judge should have looked at the form of the verdict. And I guess I wonder, under the laws in that state, again, case specific, should the judge have said, all right, we've got a problem here because this is a not guilty. This is not a hung jury on these charges.
Okay, right there. So this person is confirming that Judge Bev had to have looked at the verdict form and had to have seen that it was 12-0 on that count. So again, ethics, people. Ethics. Fucking ethics. Judge Bev had an ethical obligation, in my opinion, to say, okay, well, wait a minute. The jury came to a unanimous decision on the murder 2 count. a unanimous decision on the murder 2 count. She knew it. If she knew it, she had to have. I mean, how could she not be under an ethical obligation to be like, okay, well, I'm going to dismiss on that count, and that's it. We'll retry on the count that they were deadlocked on. The one count that they were deadlocked on. One fucking count. Dreamer Thinker, thank you so much. We are living in a simulation, right? I mean, it feels like it. Fucking wild, man. This is insane.
Charges. So that's point one. Point two is, Ted, you're absolutely right. 2 things. Number one, the jury could have been influenced by now because they've seen everything, heard everything. So how do you know when they come back and say, oh no, we all said not guilty? Has there been any bias? Has there been any changing of minds because of everything they've now heard? Number 2, a judge can never make a decision without evidence on the record. Period. Legal arguments, evidence on the record. So no matter what, if the judge is willing to consider this, my opinion is there has to be an evidentiary hearing.
That's what I say.
Yeah, for sure. And I think they didn't fill out the form. I think they thought that if what is being alleged here by the defense in this motion is true, I think they got back there. They were going through it. All right, we all agree this is it. And then they're like, oh, gee, we can't get them all. This is a mistrial. We can't. There was a misunderstanding there if what they say is true. But that's the big one. If it is true, we'll have. So Judge Wilcott, if you were in this predicament now, do you bring all the parties in and, to Jessica's point, bring the jury foreperson in to get some clarity?
I think almost you have a hearing with attorneys only to determine, is there merit? Does it need to go forward? And then if you determine under the case law, under the legal arguments, that you then do need to have a hearing, which I would suggest she might, then you do you have to bring in evidence. So you're going to have to ask the jury. And the alternative, the first thing I would do as judge is go back and get those verdict forms, right, Ted? To your point, let's see what they say. Was there a misstep by the judge? If in fact it reflected that it was 12 to 0, 0 to 12, and therefore should have been an acquittal on those charges. A lot of homework this judge has now.
And if it's true, Jessica, if you're Karen Reed, hey, I'm crying foul. I mean, the jury voted 12-0 on the top 2 charges. Cut me a break. This would be double jeopardy if you try me again.
Yes, and we know this will go, directly to everything that the defense has been saying from the get-go, and that they said, as we know, because, I was on with you when we were going back, and the judge at first said the form is fine, then came back and changed the form. The jury was out. She had to go back, and she said no, after reviewing it, that she did feel that there were some typos and some various things that needed to be changed on it. So we know that there were issues around this from the very beginning, and clearly there may have been some issues.
Thank you, Anna Banana for Fana Banana. My mom and I asked you to be our truther in pasture. We can give praise to the anti-yaks. Oh man, yeah, y'all don't get yaxed. Don't get yaxed, y'all. That's my sound advice to everyone here. Don't ever get yaxed. That means don't get sued for $10 million. Don't do that just for lying on people and defaming people. Don't do that. That's bad. Thank you, Anna Banana. I appreciate it. Truther and pastor. No.
Issues. I think, the judge and I both agree completely that I don't know in the state of Massachusetts if there is precedence for this as to what the, steps should be next. But certainly this is a boon for the defense, regardless of whatever happens next, because we know that whoever will be in the next jury pool for whatever happens going forward, everything around this, doubts are sown from the get-go now going forward.
Yeah, absolutely. In a case that was already a powder keg of emotions in this community, it's just going to explode now. The free Karen readers are going to be out in force if they do recharge or try to on the second degree.
See, man, dude, this dickhead right here, bro. Like, really, dude? Like, I was digging everything this dude was saying, and then he has to fucking be all, you know, sarcastic and snarky and shit. You know, the freaking readers, you know, and like I was really enjoying what this guy was saying, and then he pulls that shit, and I'm just like, dude, Court TV, you failed again. You fucking suck. People fucking suck. All Court TV, you're a-holes.
Ooh, you suck.
Dude. Thank you, Jen Melvin, for becoming a member. I appreciate it. Let's listen to this guy being a dick one more time.
In this community, it's just going to explode now. The free Karen readers are going to be out in force if they do recharge. Going to explode now. The free Karen readers are going to be out and flowed now. The free Karen readers are going to be out in force if the free Karen readers are going to be out in force if they do recharge or try to on the second degree murder for sure. Again, the breaking news at this hour, Karen Reed's defense filing a motion saying they've heard from a juror that claims that they were.
All right, shut the fuck up, dude.
You're a little cunt.
You sure are. Hold on. Let's drop in on Tom CPU real quick because they're demonstrating outside of the I don't know where they're demonstrating outside of, but I know they're protesting Trooper Proctor, and I'm sure there's a good vibe out here. There's no sound though. But yeah, this is happening right now, folks. Here you have the free Karen Raiders out in full force. But I don't know exactly what's going on here. But yeah, these folks here, man, they're out doing it, dude. Like I absolutely love all these folks, man. They're out there standing out, and make sure, guys, real quick, make sure to give Tom a like, y'all. Here, let me drop the link in chat. Switch over there just for a second, each one of you guys, please, and give Tom a like, and show some support for those beautiful people out there who are exercising their First Amendment right, to make sure this doesn't happen to anyone else, not just Karen Reed, but everyone. And I know Tom mutes sometimes when he's out there. Mark S. The link for that is in the description, Mark S. That is by a creator named JC Loring. Really good dude.
They all agreed on the charges of second degree murder, that they found her not guilty. He goes, I didn't believe you. Because I guess I have
Thank
to
you,
believe
Dreamer
you
Thinker.
from now on.
All right.
Oh, not
oh my
the Karen
God.
Reed song. Oh, Mark
I live in
S.
California,
Okay.
LA area.
That was Baroness. That was a band called Baroness. Great band, by the way. Which is why I played them. And the song is called March to the Sea, I believe.
I don't have a car, but I was on a public bus a couple hours ago watching the live stream. I asked the driver if he would double beep for me. He did.
Nice.
California, that is amazing. Wow.
That's the best sign in the world. I love my country. I fear my government. I love that. I mean, I hate that she feels that way because it sucks, but she's speaking the truth. She's speaking for me. I'll tell you that right now. She's speaking for a lot of the people out there in Massachusetts right now, which is what she's out there doing. All of you guys, all of you locals right there that couldn't be out there for whatever reasons, because you have personal things or because you've got a job that you can't get out of for the day, or simply just because you prefer to be anonymous, and show your support in other ways. That person is speaking for you. And it's a beautiful thing. I love my country. I fear my government. And nobody should have to feel that way.
I know, all over the world, man.
I can't stress that enough. No American, not even an immigrant, don't even have to be a citizen. Anyone who comes to this country with an American dream should never have to feel that way. Nobody who comes to this country for the reasons why they would come to this country should ever have to feel like they love the country, but they fear the government. Never.
Blessed. So blessed.
Oh, what's up, Tom? Yeah, so they're protesting Trooper Proctor, and I'm sure they're aware that they got some result, because the thing is these folks they're not just protesting Trooper Proctor. They're protesting the Massachusetts State Police. They're protesting his superiors. The only reason there's any action being taken,
MJ, buddy, how you doing? I hope you're feeling better. I hope.
The only reason that the Massachusetts State Police are taking any action against Trooper Proctor right now is because, make no mistake, because of the pressure that's being put on them right now. It's because of the pressure that's being put on them right now. And it was a bad move to not do this right off the bat. A lot of it's a little too late. You know what I mean? Like, the fact that you're aware of this behavior and you are taking your time, because this isn't about, dude, what you do is you suspend this person without pay, or with pay, whatever. You at least take them off active duty. If you were aware of these actions, which I guarantee you the Massachusetts State Police were aware of before it went to trial, before Karen Reed's trial started, I guarantee you that the Massachusetts State Police knew about those text messages. They were only put under public pressure to take action by the public. That's it. They only took action because they were put under pressure by the public. And their actions dictate this. Their actions spell this out. Or I should say their lack of actions spell this out. Because we know that the Massachusetts State Police knew about this, and he was under internal affairs investigation over his actions during this investigation. We know that they were aware of it. We know that they were aware of not only those disgusting text messages that the public is so outraged about, but also the fact that he conducted this investigation in the manner of which he did as the lead investigator. And it's very telling that Tully is not under the same investigation. It's very telling. Very telling that any of Michael Proctor's superiors are not under the same investigation. Michael Proctor is nothing but a fall guy, people. He's pacification, dude. He's a fucking pacifier. That's all he is. Or an attempt at one. It's the Massachusetts State Police going, here, public, here's your little binky. Here's your binky, suck on it for a little while. It's a taste. The public wants actions. They're hungry. And all Proctor was the Massachusetts State Police throwing the public a cracker and being like, here, chew on that. I mean, and they think we're all stupid, which is why these people are out there. They think we're all stupid. I mean, it's unbelievable, people. And the only way this corruption goes away is if it's fought, if it's stood up against. Nobody, I mean, people, it doesn't just happen. You know, King George didn't just roll over when they said, you know what, fuck the taxes and fuck tyranny. We're done with it. Farmers, merchants had to pick up weapons and fight. They had to fight. They had to shed blood. They had to die so that we don't have to live with that shit. With that kind of shit. So many people in this chat have ancestors who fought and died so that we didn't have to put up with that shit. This whole not questioning government, man, is going to be what ends up. I mean, you're just going to wake up one day and go, wait a minute. Like, you're going to want to do something that you take for granted every day, and then you're not going to be allowed to do it. And then you're going to go, wait a minute. And then it's going to be too fucking late. We still have the law on our side. We still have due process on our side. We still have amendments and rights that protect us to be able to speak up and make sure that this shit doesn't happen and it doesn't go beyond a local level. It shouldn't even happen locally. But the fact is, it's happening locally in Massachusetts, in the Commonwealth of Massachusetts. These people are getting robbed of their basic rights every day because of a corrupt government. This is happening. And then these people who are standing out there are getting dismissed as crazy in the media. They're being dismissed as free Karen readers. You know? Because they fail to even acknowledge the one simple fact that this is just this much about Karen Reed, but this much about everybody who lives under that umbrella of corruption in Massachusetts. failing to realize this. It's something that we need to keep in mind and think about every single day, folks. If you live under the blanket of freedom in this country, this affects you. I assure you. And my hat's off and my undying respect to every single one of those people that are standing out there today and have been standing out there in front of that courthouse every single day for not just Turtle Boy or Karen Reed, but for Turtle Boy as well. The Canton Nine. And on that note, guys, I'm going to leave you with it. I still got faith that we're going to see justice, folks. I still got faith. Guys, I love you very much. And we will do this again very soon, my friends.